This is unbelievable. This is one of the greatest things that has happened in 30 years. I mean it. Scotus sides with straight woman in bombshell reverse discrimination case. Ladies and gentlemen, I've said on this podcast for years that when Barack Obama became president and he appointed the racist Eric Holder to run the quote-unquote Justice Department, and they decided that you can't discriminate against the majority. You can only discriminate against minorities. And so they would not defend the rights of any majority ever, anywhere. And that lie, that legal manipulation has lived rent-free in our country because no Republicans would fight against it, because no one dared to say, that's stupid. You can't discriminate against anybody. That's what equal justice under the law is. The Supreme Court of the United States just voted 9-0 to uphold that. And baby, DEI is DOA, okay? It's dead. On Thursday, the Supreme Court of the United States handed down a decision surrounding a straight woman's reverse discrimination case against her former employer. The High Court ruled unanimously that the plaintiff, Marlene Ames, faced a high hurdle to sue her former employer than if she had been gay. The ruling states that members of a majority group do not need to show background circumstances in addition to normal requirements to prove a claim under the Title VII of the Civil Rights Act of 1964, which protects Americans from employment discrimination based on race, religion, sex, national origin. Scotus rejected a lower court's ruling that Ames could not sue the Ohio Department of Youth Services because she failed to provide background circumstances showing the department was discriminating against the majority. Ames, who worked at the Youth Services for 20 years, sued because she had been passed over for promotion and demoted in favor of gay colleagues. From the Hill newspaper, the Ohio Department of Youth Services hired Ames in 2004 and a decade later promoted her to become administrator of the Prison Rape Elimination Act. In 2019, she interviewed for another job at the department, was not hired. Her gay supervisor suggested she retire, and days later, Ames was demoted with a significant pay cut. A 25-year-old gay man was then promoted to become the PRE administrator. And months later, the department chose a gay woman for the role of Ames unsuccessfully applied for. The three-judge Sixth Circuit Court of Appeals panel agreed Ames would have prevailed if she were as a gay woman, but they ruled against her since she didn't meet the additional requirement as a party of a minority group. They were basically saying, you can discriminate against the majority. And the Supreme Court said, no. We conclude that Title VII does not impose such a heightened standard on the majority group plaintiffs. Justice Ketanji Brown Jackson from the left wrote for the court, and nothing Ohio has said in its brief or at oral argument persuades us otherwise. Despite the woke ideology of the radical left, the Supreme Court has ruled discrimination against the majority is unconstitutional. Discrimination is discrimination, plain and simple. You and I have known that our whole lives. The left had bastardized our laws to pretend that wasn't true, and now let the freaking lawsuits begin. Everybody you know who is white, who has been discriminated against in the last 20 years, call your lawyer today. Sue the hell out of them. That's what we fought for. That's what electing Donald Trump was for, to restore equal justice under the law for all. The Supreme Court just ruled 9-0 for that. Do you realize how huge this is? This is massive.